Afternoon, sir. Can you see and hear me?
I can indeed.
Thank you. We are going to hear from K-L.
Yes.
Stand. Yes, please. I'd like to repeat after me. I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you. Thank you.
Please could you state your full name?
K. Catherine Sheila Hillary Linnell.
Thank you for attending the inquiry to give evidence today. You have produced a written witness statement. Could I ask you to turn that up, please? Do you have it? That's in front of you. Excellent. It should have the date in the top right of the 16th of May 2024.
Yes, it does.
Thank you. For the record, that unique reference number is WITN 00550100. Now, before I go to your signature, could I ask you to turn to page 24, please? Paragraph 91. It doesn't need to be shown on screen. You, on the first line, refer to Joe Swenson, well, spelt with an E. I understand you wish to correct that to Swinson, spelt with an I.
Yes, please. A spelling mistake. And it's the first of two paragraphs 91, which is a numerical mistake.
Yes. Could I ask you to turn to page 41, please?
Yes.
You should see paragraph 157, and then below that, a statement of truth with your signature.
That's my signature, thank you.
And can I ask, are the facts in that statement true to the best of your knowledge and belief?
They are.
That will stand as your evidence in the inquiry, and it will be published shortly on the website. I'm going to ask you some questions about it, but before I do, I understand you'd like to make a statement.
Yes, please, thank you. Before I start, I'd like to say this is a good opportunity to pay tribute to those who've worked very hard behind the scenes to help the SPMs to right the miscarriage of justice that has been brought to light. There are many unsung and unseen heroes, and I've been personally supported very strongly by Howe & Co in this matter, and before that by Freeths in the High Court litigation and by other firms such as Hudgels. I would like to pay my respect and thanks to them because a lot of what they've done has been unpaid and unnoticed. Their support continues. One other person I would like to nominate for a special vote of thanks, so to speak, on behalf of the SPMs and myself, is Barbara Jeremiah, my business partner. I slightly blame her for becoming involved in this because Barbara always believed in Joe Hamilton's innocent and would not believe me until we got involved. Joe is our local postmistress, or was, and Barbara's worked tirelessly, providing support, guidance and encouragement to many sub-postmasters in the very many years we've been involved. Barbara's been involved in almost 20 years and has never once wavered from her steadfast belief against impossible odds. Barbara's never refused a request for help from any SPM and has always been mindful of the damage inflicted on them and their families by the malicious, incompetent, coercive, controlling behaviour of the shape-shifting post office. We will continue to give support to SPMs in every way we can through accountancy, taxation, counselling and advice, and any SPM who needs advice should contact us until the money wrongly extracted from them and the damages to compensate them have been paid in full. The new post office team appear to be no better organised than the old one through recent events, but I will not mention that. Thank you.
We are not going to cover any recent events. We'll look at matters in the inquiry's terms of reference. I'm going to start with your background, please. And you qualified as a chartered accountant in 1979.
Correct.
And you now work as a forensic accountant.
That's correct.
When did you first start to act as a forensic accountant?
Possibly in the late 80s, early 90s.
And from that point, the late 80s, early 90s, did you work for a firm or on your a self-employed basis?
I began engagement with fraud when I was a partner in a small firm of chartered accountants in Derby. And having discovered fraud, I applied to and joined the Inland Revenue and ultimately became the Board of Inland Revenue's Chief Investigating and Prosecuting Accountant and Head of Accounting Profession, prosecuting several well-known figures. I then left HMRC as it became, and I set up the Joint Insolvency Monitoring Unit to monitor insolvency practitioners. I've also worked in industry for Forte PLC as head of UK taxation, and I then went back into the profession with a small London firm of accountants, and I was then headhunted by Smith & Williamson to set up a Southampton branch as a forensic accountant, and latterly by BDO. In about 2010, I set up my own practice.
So when you were first engaged in or involved in matters relating to SPA sub-postmasters, for whom were you working at that stage?
I was working for myself. It was about 2012.
And I think you mentioned BDO you were employed by BDO, did you?
Yes, I was the forensic director in Southampton.
What was the full name of the BDO, sorry?
I think at that stage it was BDO LLP, I forget.
Could I start with your initial interaction then with sub-postmasters and the sub-postmasters cause? Could we please bring up the witness statement at page 2, paragraph 5? If you could, if you go to page 2, please. Thank you. And if we could have paragraph 5 at the top. So you say I became involved in the Post Office treatment of its sub-postmasters in 2009 because of my local sub-postmistress, Jo Hamilton. You then referred to your business partner, saying you used to drop into Jo's shop in South Warnborough to buy her lunch on the way to court. One day in 2005, she found Jo in tears because of ever-increasing unexplained shortfalls in her business accounts. And you go on to describe some aspects of the criminal trial. Can I just clarify, were you first made aware of Jo Hamilton's case in 2009?
No, earlier than that. And I did try and get involved in 2009, but my real first involvement with Sir Alan was 2012.
Thank you. So is it fair to say that you were aware of some facts of the issues, you were aware of Miss Hamilton's case before you became involved with Sir Alan, but it's only at that later stage in 2012 when you became involved?
Yeah, you could almost say I sort of got my hands dirty from 2012 onwards, but I was well aware of it much earlier than that.
That can come down, thank you. You go on to say that your business partner suggested that you spoke to Jo Hamilton in June 2012.
Yes, that's right.
And at that point, you were, I think it was Miss Hamilton suggested that you spoke to Sir Alan.
That's correct.
Now, had you heard of Sir Alan before before you spoke to him?
Yes, indeed. Mrs. Hamilton told me all about him regularly.
And can you recall your initial meeting with him?
I met Sir Alan outside James Arbuthnot's office in a first meeting which we were going to have with James Arbuthnot and Ron Warmington and Ian Henderson of Second Sight.
So I'm going to come to that meeting shortly, but that's the first, effectively.
That was my first physical meeting. I had had a couple of telephone calls with him.
I just want to ask a few points about representation generally, and starting with the JFSA. At paragraph 9 of your statement, you say that JFSA is an unincorporated affiliation with no constitution, rules, or hierarchy, but simply united by a common problem, which is to get back the money wrongly taken by Post Office and attempt to recover losses and damages caused by the Post Office operation of the Horizon computer and support system in the Sub-Postmaster Post Office network. You say no hierarchy. Was Sir Alan the chairman of the JFSA?
In one way, he was effectively the person driving a campaign, and the SPMs that I met preferred that he led the way for them. I don't think there's an officially recognised hierarchy or structure where there's a chairman, a secretary or treasurer or anything like that.
And how was decision-making on behalf of the JFSA as a whole? How did that decision-making happen?
It happened at group meetings by show of hands.
When you joined it, when you first met Sir Alan in 2012, can you recall roughly how many sub-postmasters or former sub-postmasters formed part of the JFSA?
I don't know that information.
Do you know how the JFSA was funded at that time?
My understanding is it had no funding.
At that time, had you had any contact with the NFSP?
None whatsoever.
Let's go then to the meeting in July 2012, and I think you say that that was with Sir Alan, Ron Warmington, Ian Henderson and Lord Arbuthnot.
Correct.
Before that meeting, what had you been told about the purpose of it? The purpose of the meeting.
I was told the purpose of the meeting was to consider a mediation proposal put forward by the Post Office.
So, did you say mediation proposal?
A mediation proposal put forward by the Post Office to James Arbuthnot, which he wanted JFSA to sign up to try and resolve the, I think it was 47 MP complaints about SPMs.
Pausing there was obviously the mediation scheme, which we'll come to after the interim report in 2013. This in July 2012, prior to the second site interim report. Was this still described to you as a mediation proposal?
My recollection, which may not be that accurate at this remove of time, but my recollection was there was looking to be a mechanism to resolve the disputes effectively raised by the 47 SPM complainants through their MPs. And they wanted an initial external independent forensic firm of accountants to look at it.
And prior to that meeting, had you had any experience of, or dealing with either Ron Warmington or Ian Henderson?
None whatsoever. I looked them up before meeting them, but I wasn't certain that they weren't people put up to do a whitewash burial job by the Post Office.
So we can actually bring up your witness statement, please, at page 4. And there you say, I was extremely suspicious of Second Sight as they had been nominated by Post Office as independent forensic accountants. And I was concerned that their access to documents and review of Post Office's Horizon system might be a whitewash. I challenged them at our meeting in 2012, but was satisfied with their responses. Can I ask you, your recollection of how you challenged them at that meeting?
I recall I asked them various questions about their background and approach to what ended up being the spot reviews of the cases.
And do you recall what they said to satisfy you?
Not precisely, but I wanted to know what documents they were going to look at, what level they were going to look at in the IT support, and whether they were going to meet the complainants.
You said in your evidence then what ended up being the spot reviews. Had the concept of, from your recollection, was the concept of spot reviews discussed at that meeting?
Not to my recollection, no.
Do you recall broadly what the proposal from Second Sight was?
I think the initial proposal was to pick several of the 47 cases and do an in-depth review of each of them to try and find out what had gone wrong and whether the complainant had any substance in what they were saying.
So that at that stage, a focus look into specific cases raised by MPs.
Yes.
Lord Arbuthnot produced a witness statement and gave oral evidence to this inquiry. The witness statement was dated the 12th of March, and he recalls this meeting taking place on the 12th of July 2012, and his evidence was that you and Alan agreed or were satisfied and agreed to the appointment of Second Sight at that meeting, with the caveat that you would be able to double check that Second Sight were acting independently. Would you agree with that?
Yes, that's correct.
And at that point, how did you envisage checking on Second Sight's independence?
At that stage, I thought I would be acting as an independent forensic accountant for JFSA, and I believe at the time I prepared a letter of engagement, and it was agreed I'd be paid a small fee for checking their work and going round with them, just to see what they were doing.
Let's look at that letter of engagement now. It's exhibited to your witness statement at WITN 20550-101. Is this the letter to which you were referring?
Yes, it is.
It's dated the 6th of July 2012, so shortly after the meeting with Lord Arbuthnot and Second Sight.
16th of July 2012.
16th, sorry, did I say the 6th? I do apologise. 16th. If we could go down, please. And we see scope of our work. It says, well, firstly, a sentence about acting as expert accountant. And
Yes.
refers to Second Sight. The second sentence says, the initial investigation will be in two parts. The first being into current errors, the second to investigate the historic cases which have been raised by MPs and a number of cases you will recommend.
That's correct.
So is that broadly what Second Sight were suggesting at this time, or at least your understanding of it? A look at first tranche current cases and then more historic ones in a second tranche.
That was my understanding.
At this stage, was there any discussion from your recollection of systemic errors or looking for systemic errors?
No, not at all.
That document could come down, thank you. And if we could bring up the witness statement, please, page 4, paragraph 15.
Before that comes up, Mr. Stevens, can you remind me to whom that letter was addressed? I saw that it was on Mr. Linnell's note paper, but to who, it's dear sirs, is there a
Yes, the addressee is Justice for Sub-Postmasters
Right.
Alliance.
Yeah.
But actually, so you're quite right. The question I should ask, if it's an unincorporated association, is to whom was that letter sent?
It was sent to Alan Bates.
There we are on the witness statement. So paragraph 15, you refer to attending a meeting at Post Office with Alwyn Lyons and Paula Venables. You say, I think, around June or July 2013.
That's correct.
Had you met with Alwyn Lyons and or Paula Venables before then?
I don't think I'd met Alwyn Lyons before then, and I think I had seen rather than spoken to Paula Venables. There was a briefing day in the September of that year when I definitely met them, but I don't recall meeting them before then.
And the interim report is produced on the 8th of July 2013.
Yes.
Was this meeting before or after the interim report?
Unfortunately, I can't find the date, but I believe it was before the interim report was released.
But you're confident that it was 2013 and not 2012?
Yes.
We'll come back to that meeting then in due course. Can I please ask for us to look at POL 30911028? If we could go down, please. Thank you. So we have a email from Ronald Warmington to Mike Wood MP. You're not in copy to this, so you wouldn't have seen it at the time, presumably.
No.
And have you seen it for the first time when preparing for the inquiry proceedings?
That's correct, yes.
The second paragraph of that email says, the idea of carrying out a deep dive into Horizon is on hold until we have completed the case reviews. Few of us think that sort of review will work well. Some of us think it will probably turn out to be a colossal and expensive disappointment for those seeking evidence of anomalies in Horizon. Those pressing for such a review now seem happy to wait to see what the case reviews throw up. Do you have any recollection of between the meeting you had with Second Sight on the 12th of July and this meeting on the 18th of July, of any discussion about a deep dive review or specific case reviews?
No, we only had the one meeting to start the process off. I think it's referring to our first meeting.
And at this stage, you were happy with the case reviews approach?
I think if you didn't approach it through case reviews, you wouldn't know what anomalies you were looking for. You'd be checking 100% of the system at vast costs, and it would take an enormous amount of time. So I do agree with starting with the problems and then working back to see what went wrong.
Thank you. That document can come down. Please can we bring up your witness statement at page 11, paragraph 47. Thank you. Now, this is something I've already touched on. You say here about the distinction between systems error and systemic error. You say that it's worth noticing the difference between a systems error, brackets, that is an IT coding error that will replicate an error of the entry of the same data and processing of transactions in the IT system, close brackets, and a systemic error, open brackets, that is one caused by incorrect implementation and management of the sub-postmaster network using the Horizon Computer Accountancy System. Were those concepts of, as you described them there, discussed with Second Sight in 2012?
I think the first time the word systemic error was used was in a letter from Sir Alan to, I think, James Arbuthnot. And the difference between Ron and Ian's definition of systemic errors and ours is theirs was restricted solely to the computer system, whereas Alan and I saw and see Horizon as to be a complete system of administration, training, implementation, and management using the computer Horizon.
Could I, do I take it from that then that there wasn't a discussion with Horizon on the difference between systems error and systemic error in 2012?
Not that I recall.
Could we look, please, at the interim report? It's POL 30/99063. And if we could go to page 22, please. So this is an appendix to the interim report, which sets out, says the remit of the inquiry. So the remit of the inquiry will be to consider and to advise on whether there are any systemic issues and/or concerns with the Horizon system, including training and support processes, giving evidence and reasons for the conclusions reached. Do you recall when the first time you heard the inquiry expressed like in those terms was?
I think it was on the publishing of this report, which I didn't see in draft before it was published. I just saw the final version.
Keeping at the time when the Second Sight review was commissioned, so July 2012, what at that time was your view of the Post Office's motivations for commissioning that review?
Personal opinion is that they wanted to settle the MP's complaints and make it quiet.
What was that based on?
It was based on the attitude of the Post Office in falling over themselves to provide information about those particular cases and nothing else.
In your view at the time, what, if any, other options were open to the JFSA to push forward with the sub-postmaster's concerns?
The JFSA were an alliance of people who had similar problems with the Horizon system, who'd suffered personal damage, but had no information whatsoever. If it could be taken to the next stage of taking it to the court, the SPM's JFSA required evidence, and there was no way of getting evidence from the Post Office except through MP complaints. So there was no other course of action they could have taken at that stage, in my personal opinion. On Tuesday, you'll know that they're not backward at telling their views about things. So, yes, they had.
And what's your recollection of what they said?
My recollection was they found sufficient errors, defects and problems that the complaints by the sub-postmasters through their MPs were generally being found to be based on errors in the Horizon system.
At that stage, how satisfied were you with the work that they had and were carrying out?
I was very satisfied that they were trying to do their best to get information from Post Office to answer the question we'd all been asking, why have these differences occurred?
At that stage, so January 2013, had either Mr. Warmington or Mr. Henderson mentioned a concern that there may have been miscarriages of justice?
No, we didn't discuss criminal prosecutions or miscarriage of justice. We were simply looking to try and find out why the errors had occurred.
Please could we bring up poll 30988315? So if we can move down the page slightly, please. Thank you. We have an email from Sir Alan to Ron Warmington on the 12th of May 2013. I believe that our data protection has covered up the email address, but I believe that's you in copy. Is that right?
Yes, I was copied.
It's responding to quite a lengthy email from Mr. Warmington, which I don't need to take you to. It's the, as you may expect, it's the system errors and systemic failures that I want to deal with. And it says, I think there may be at times confusion by others over the referencing of these 2 points. At its most basic, system errors would to me be something like an extra loop in the software code causing the false result of a transaction. But as you rightly say, that would affect every one of the 11,500 officers. Then at the other end of the scale, it might be something far more complex, resulting from a network communication failure and an incomplete recovery of a transaction at a particular office. And it goes on. And Sir Alan goes on to say, now systemic failures, on the other hand, are different. And in my letter to James Arbuthnot, now pausing there, was that the letter to which you referred earlier in your evidence as the first time you recollect this issue arising?
Yes, that's my recollection.
You see, where I first used the phrase, I've qualified its context. This occurs in the first sentence of paragraph 2, where I say, the weight that it adds to the systemic failures with Post Office and their Horizon system. It is these systemic failures with Post Office and their Horizon system that are the proven facts. Now, do you agree with that definition of system errors and systemic failures?
Yes, I do.
Did you have any further discussion on that distinction with any representatives of Second Sight following this email?
No, I left this to Alan because he had some experience in point of sales and software, and frankly, I'm too old. I'll use pen and ink, really.
Before we move to look at the interim report itself, to what extent were you aware of Fujitsu's involvement during the... Sorry, I'll rephrase that. To what extent were you aware of Fujitsu being consulted by Post Office during the Second Sight investigation?
I assumed at this time that Fujitsu held some of the electronic evidence and data, and they would have to be asked by Post Office to produce it. I'm not aware of any consultations.
So is it fair to say that was an assumption you made because they operated the computer system, but you had no direct knowledge of Post Office contacting Fujitsu?
Not at that time, no.
At that time, had you heard of Gareth Jenkins?
No, I had not.
I said it would be before I moved to the interim report, but of course I put off the question I was going to ask earlier about a meeting with Paula Reynolds and Olwen Lyons. Could we please bring up your statement at page 4, paragraph 15? Paragraph 15, please. Thank you. So you refer to, again, this meeting in either June or July 2013, and my understanding is that this was before the interim report came out. That was your evidence earlier.
Yes, that's correct. And I believe it was requested by Post Office. We'd written and asked for a meeting, I think, on around the beginning of June 2013. And the date was suggested by, I think, Paula Vanells.
Well, let's see if we're thinking about the same email. Could we bring up POL 30s98418, please? And if we could go to the bottom of the page, please. So there's an email there from Sir Alan on the 21st of May 2013. And the the last paragraph on the page says, would it be possible for Kay Linnell and I to meet with you? Is that the email you were referring to?
Yes, and I think there's some subsequent emails where she comes back. And I think a date of the 5th of June was suggested, but that wasn't convenient. Yes, it's down there at the bottom of the page.
So looking at this email, Sir Alan refers to you and your who you were as a reminder. If we can go down, we see that he says that the main purpose of the meeting is to ensure that you've been receiving the full details of what has been occurring with the second site investigation. Bearing in mind what has been discovered so far, I, for one, am surprised that we haven't yet met to discuss the implications. Now, pausing there, at that stage, what had been discovered so far that prompted an email from Sir Alan? I should just ask, sorry, did you and Sir Alan discuss this before sending it?
Yes, we regularly discuss things and swap drafts. And as I recall, what had been discovered is there had been substantial and important errors in the operation of the computer, which had caused differences and shortfalls in SPM's accounts. And it was at this stage we had, from the spot reviews, evidence that Horizon did not operate perfectly and left differences.
It goes on to say, at the final sentence of the paragraph, I have little doubt that it is now feasible to show that many of the prosecutions that Post Office have pressed home should never have taken place. And I believe this is a view shared by Kay. Was that a view shared by you?
Very much so.
And again, just so we're clear here, what was it at that stage that led you to believe that it was feasible to show that many prosecutions should not have taken place?
Bearing in mind I had personal knowledge of Jo Hamilton's case, and her case was taken to the doors of the trial before a plea bargain without any evidence being given to Jo to check as to how and why the errors arose. When Second Sight started their spot reviews, they also found that there were errors which hadn't been disclosed to people who were prosecuted as part of the spot cases.
Just pausing there, when you say errors, can you remember putting yourself back to the time what those errors were which led you to believe this?
I can't remember which names the bugs had.
But is it bugs that you're referring to?
It's bugs. And everyone's called them bugs, but they're actually errors in the computer software programming that when you put in a certain series of transactions always cause a difference. And as the Post Office read the contract, that it was always the sub-postmaster's fault or liability, whatever the circumstances, it was clear to me that money had been taken wrongly, and also, as in Joe's case, they had relied on the computer figures to mount a prosecution, and I therefore felt at that stage prosecutions might or probably were unsafe.
Was that the prosecutions being unsafe? Let me rephrase it. Who did you discuss your concern that prosecutions may have been unsafe, other than Sir Alan and, by way of this email, Paula Venables?
Nobody, because it's a suspicion, not evidence. And as a forensic accountant, I have prosecuted people while I was at HMRC, Inland Revenue, and I am aware of the standard beyond reasonable doubt and the evidence required to show criminal intent, none of which appeared to be present in Joe's case. But I was not aware of sufficient evidence to take that anywhere else. It was a suspicion.
The last question I'd like to ask on this email is the use of the words, the main purpose of the meeting is to ensure that you have been receiving the full details of what has been occurring. Do you know why Sir Alan used that turn of phrase?
We actually discussed this. It's a question we thought of the Post Office being a former government organisation which had silos, where, for example, the legal department appeared to be completely separate from the operation and management department of the Post Office network, and there appeared to be management layers between them and the board and the CEO. So Alan and I wanted to make sure the people at the top knew exactly what had been found.
If we then can go back to the meeting which we had in your witness statement. So if you could bring back page 4 of the witness statement, please, paragraph 15. So it says that we asked to meet Paula Venables, the CEO, to try to get a reality check on the Post Office opposition to recognising the plight that Post Office had caused sub-postmasters, to admit Horizon was not 100% perfect, as no computer system can be, and to get money paid back to sub-postmasters as soon as possible. Going to say, at that stage, JFSA did not want a full public exposure, just proper care for SPMs in giving money back wrongly taken and paying for losses and damages. We were asking for substantial amounts, but nothing compared to their own bonuses, published in great detail in the Post Office Limited annual accounts. There you don't refer to prosecutions. Did you not discuss that with Paula Venables at this meeting?
As far as I can recall, we discussed everything, and we were slightly worried that they'd used no evidence at all to mount criminal prosecutions without any idea of whether there was a guilty mindset or not. But I didn't refer to it there because I am not certain. I don't have any notes of that meeting. I can't even find the date of it, unfortunately.
From your recollection, what do you think you said to Paula Venables and Alwyn Lyons about your concerns as to criminal prosecutions?
I believe Sir Alan and I have always been concerned about giving money back to sub-postmasters who were in dire financial straits, having had money taken away from them. And the thought about prosecutions was something we suspected but couldn't prove or worry about. As in 2013, so many years ago, we wanted the money given back to people it had been taken off. And that still is a primary concern. And, you know, I'm sorry to expand on the answer, but I recall that all we got from Paula Vanel's was her main purpose was to learn from the past and build the brand and make it profitable, which is not an answer to our questions at all.
Do you recall there being any discussion on or proposal put forward by either Alwyn Lyons or Paula Venables that went to concerns about either criminal prosecutions or giving money back to sub-postmasters as you requested?
No, none.
Okay, that document can come down, thank you. Please, could we, actually before we go to that, the interim report is, we know it's published on the 8th of July, 2013. What, if any, involvement did you have with looking at or discussing drafts of the interim report with Second Sight?
None whatsoever.
Did you have any discussion with representatives of Second Sight more generally about the content of the, not specific drafting, but the content, the general content of the interim report before it was published?
Not before it was published.
What did you understand the purpose of Second Sight releasing the interim report to be? And just be clear, my question is before it was released.
Before it was released, I believe there was some pressure, particularly from James Arbuthnot was my MP as well as Joe's. And I think there was some pressure from the MP committee, led by James, to actually give some sort of interim report as to what the Second Sight investigation was finding. So I believe they selected a few cases, 4 or 5, and produced effectively a distilled analysis of them. Before they produced it, I expected it to be a full, in-depth analysis of them.
That purpose of producing a interim distilled analysis of 4 or a select number of the spot reviews, did you think that was or what did you think of that as an idea?
Not a bad idea, because it might start the ball rolling towards giving money back, I thought. And as long as it's only a stepping stone along the way in their inquiries, it wouldn't make any difference.
Was there any discussion before the interim report was published as to what was envisaged to happen to Second Sight's investigation after it was published?
No, I don't believe there was a discussion. I think it was an understanding that the Second Sight investigation would continue until they'd finished the sub-postmasters' complaint cases, the ones from the MPs.
Sorry,
No, beg your pardon.
I overcut you there. I was about to ask. You said until they've finished the sub-postmasters' complaint cases, and then did you say the ones from the MPs, as in the cases referred by the MPs? And
I think they were augmented in some way by a few added by post officers' sample cases from memory.
You referred to an understanding that Second Sight's work would continue. When you say that understanding, was that just your understanding or one shared by others?
The original engagement of Second Sight was by the MPs, countersigned by JFSA, and Post Office were used by the MPs as a vehicle to implement the contract and pay, because the MPs did not have a budget. So my understanding is the MPs were instructing Second Sight, nobody else, and the MPs wanted an answer to their queries.
Could we look now at the interim report, please? It's Poll 3099063, and if we could look at page 8. The preliminary conclusions are very well known to the inquiry. We see the no evidence of system-wide (systemic) problems, and B, referring to 2 incidents or where defects or bugs in the Horizon system, and it goes on to refer to two of the bugs that the inquiry has heard a lot about. What did you think of, in particular, these two preliminary conclusions at the time?
I was particularly disappointed by conclusion A because I didn't think there was sufficient data for Second Sight to reach that conclusion. I don't think they should have opined at all on whether there were systemic problems at that stage. I also found in my own research following them round that they had found problems across the system where one error would affect many, many branches, and I was therefore disappointed.
Just taking that in stages. Firstly, you say that disappointed because they didn't think they had the evidence to say that. The fact they've said we have so far found, so saying we haven't found evidence of a systemic problem, did that not reassure you?
Quite the opposite. It made me think Post Office had interfered with the report.
And when you said that you felt you had seen evidence of system-wide systemic problems, do you recall what, at the time, what you thought those were?
No, I can't recall. There was something to do with ATMs, but I don't remember whether that, and it was the Bank of Ireland, but I'm sorry, my memory of that is very hazy. I just remember being quite cross about this because they shouldn't have put anything in without the evidence to support it. And from what I'd seen of Ron Warmington and in Henderson, they were very thorough. So I don't believe on their own they would have written that.
But just to be clear, you weren't involved in the drafting process, so you don't have any direct knowledge of how this report was drafted.
None whatsoever.
Can we turn to page 12, please? This is Spot Review 5, which concerns the allegation that had been made by Michael Rudkin regarding what's now referred to in shorthand as remote access. And the inquiry has seen this a lot. I don't need to go through it in full. If we could just look at the bottom of page 13, please. Saying we are left with a conflict of evidence on this issue and our inquiries are continuing, particularly in the light of new information confirming that the meeting on 19th of August 2008 did in fact occur. Were you told anything about Fujitsu's ability to access data or insert data into branch accounts remotely prior to the issuing of the interim report?
Yes.
What were you told?
I was told it was possible to enter the system through a back door and it was a systemic error.
Who told you that?
Well, believe it or not, I think it was Ron Warmington, but I've certainly talked to Sir Alan about it, and we knew about the Bracknell and other parts of Fujitsu who regularly made corrections to the live system.
So you spoke about it with Sir Alan, and I think you said Ron Warmington discussed it with you. At this stage, so when the interim report was released, were you aware of Gareth Jenkins as a person?
No, I'm still not aware of Gareth Jenkins at this stage.
You say in your statement, we don't need to pull it up, that you thought the interim report could have been much stronger with regard to the Post Office limited field of operation and systemic working errors. And in your overall evidence, you've expressed frustration about the report. Did you discuss that with did you discuss your feelings on the report with either Mr. Henderson or Mr. Warmington at the time?
After the report was issued, yes.
What did you say to them?
I was disappointed.
And what was their response?
I don't exactly recall what they said, except that, they'd had to discuss the draft with Post Office and clear it, which I still don't understand.
I want to now look then at what happens next in the chronology. It's the mediation scheme. Were you involved in any discussions with post office representatives following the publication of the interim report about what to do next following its findings?
Yes, there were extensive discussions, generally led through James Arbuthnot and Alan Bates, about how we should go forward from the interim report. Because although I thought they'd carry on finishing the job, it was clear they wanted to take a different line.
And when you say it was clear they wanted to take a different line, how did you come to learn of that? And when you say they, do you mean Post Office?
Post Office, I'm sorry, I should say. Post Office wanted to be seen, in my view, as reacting to the interim report in a positive way.
Were you involved in the initial discussions as to the establishment of what became the mediation scheme?
Yes, I was.
Who else was involved in those discussions?
Sir Alan Bates, Ron Warmington, Susan Crichton, Ian Henderson, James Arbuthnot. Possibly some others.
So on behalf of Post Office, it was Susan Crichton.
Susan Crichton led the discussions.
And can you recall, in terms of dates, when those discussions took place?
They were sometime around August 2013.
What was your view of Susan Crichton's approach to the issues in the mediation scheme?
She struck me as somebody who was trying to get to the bottom of what had gone on and to put forward some redress or remediation for the people who'd been caught up in it.
Do you recall when the working group that oversaw the mediation scheme, do you remember when that first became suggested as an idea?
The working group was merely a part of the mediation scheme, and I think it was called the Initial Complaints and Interim Mediation Scheme, as it's supposed to be a model where we tested whether complainants could get redress. And I believe it started with a training session in September 2013, which I attended with Julian Wilson from the JFSA.
We can, if you look at that now, if you could bring up your witness statement, please, page 18, paragraph 66. So you say, as you rightly say, you say that it was attended by Julian Wilson, and you say that the training day was also attended by Second Sight, and presentations were given by Susan Crichton, Angela van den Bogert, and Andy Parsons. Can you, is this the first time you'd met Andy Parsons, or had you met him before then?
No, I think this was my first meeting with him.
And do you have any recollection of his approach to the training session itself?
The training session was done in such a way to explain the background to the way Post Office operated and its structure, and Andy Parsons gave some legal overview. I forget the details precisely.
And Angela van den Bogert, was that your first dealing with her, or had you met her before?
No, this was my first dealing with her.
And again, the same question, what was your view of her, sorry, I'll rephrase that. What was your view of her approach to the training day and the mediation scheme at that point?
Her approach was to tell us sufficient to understand how the network was managed by Post Office and the duties of the sub-postmaster.
Please, could we look at WITN 20550103? And page 11, please. Actually, no, if we start on page 1, usually a good place to start. I think this is exhibited to your witness statement as a presentation given at this trading day. Is that?
That's correct. This is a copy of the slide deck.
Could we turn to page 11, please? So we see Bond Dickinson at the top. Can we infer from that that it would be Andy Parsons giving this part of the presentation?
This is Andy Parsons' presentation.
And we have possible remedies. I want to ask about two. Can you recall what was said about compensation?
My recollection of this day is quite muddled, to be honest. I have a feeling he said if there is something that's been done wrong, clearly the post office will compensate you, or some wording like that. My notes are also pretty fuzzy because I'm talking to people and presenting as well. But I think it basically was that they would pay compensation to people who had suffered if there was an error proved by post office.
And I appreciate you say your memories, I think the words were quite muddled, but do you recall what was said about support a criminal appeal?
Again, if the evidence, I think my recollection is that Andy Parsons said if there was a proven miscarriage of justice, they would support a criminal appeal. Just as an aside, if I may, you would have thought if they'd known about Gareth Jenkins at this stage, they would have actually told us in the briefing.
Can we look, please, at poll 30222120? This is a document titled Overview of the Initial Complaint Review and Mediation Scheme. Was this a document to which the JFSA had input?
Yes, we had a lot of input.
And was it an agreed document?
In the end, yes. It was compromised in various parts, but it was generally agreed.
Throughout my questions today, I'll come back to this, and there may be points when I ask you where there's been compromise, but I'm not going to ask you for the whole of the drafting by committee. Could I look, please, at page 5? We have frequently asked questions about the scheme, and at the bottom, a bit further down, please. Thank you. What if my case involves a completed criminal prosecution or conviction? So you may put your case through the scheme even if you have already received a police caution or have been subject to a criminal prosecution or conviction. However, Post Office does not have the power to reverse or overturn any criminal conviction. Only the criminal courts have this power. If at any stage during the scheme new information comes to light that might reasonably be considered capable of undermining the case for a prosecution or of assisting the case for the defence, Post Office has a duty to notify you and your defence lawyers. You may then choose whether to use that new information to appeal your conviction or sentence. You may have already answered my question. At this stage, were you aware of the advice of Simon Clarke, dated 15th of July 2013, which raised allegations that Gareth Jenkins had breached his expert duties to the court?
I believe the Clarke advice was only disclosed in March 2021 after the criminal appeal trials.
At this time, were you aware of the substance of the allegations, namely that Gareth Jenkins had produced expert evidence in breach of his duties to the court?
No, I wasn't aware.
At this stage, were you aware that Post Office was conducting an internal investigation into past convictions?
No, I wasn't aware.
So that might be a good time to stop for the an afternoon break.
Yeah, that's fine. What time shall we resume?
Could we say 3 o'clock, sir?
Yeah, by all means.
Thank you. Sir, can you see and hear me?
Yes, I can. Thank you.
Thank you. I want to carry on with a few points on the mediation scheme now. Could we please have your witness statement on the screen, page 20? Go to the page before, please. Thank you. And at paragraph 76, you refer to Belinda Crowe as being the appointed administrator and act as secretary to the working group.
Correct.
You say at 77, I was not aware at that time that Post Office had a separate committee chaired by Belinda Crowe called Project Sparrow, which was only revealed after the High Court trials. The fact that JFSA did not know about this is typical of Post Office Limited's behind-the-scenes obsession with secrecy and control. At the time, did you have any concerns as to the appropriateness of Belinda Crowe's appointment as a person to provide secretarial support to the working group?
I didn't know anything about Belinda Crowe except she was a post office employee. I'm not sure that anybody else was able to afford the services of a secretariat to manage the case flows and assist with the disclosure exercise of Post Office, which was headed up by Angela van den Bogaert's investigation team. And I just accepted her as someone nominated to do a job. But what I wasn't aware of, which is what those two paragraphs indicate, that she was senior in Post Office and not just a secretary or somebody, and that she seemed to be chairing some group of people who are working against the disclosure and settlement of the cases. It's disingenuous in terms of a mediation scheme.
With hindsight, with that knowledge now, do you have any concerns as to whether or not it affected the mediation scheme or disclosure within it?
I believe it affected the recording of the minutes and the progress of cases through mediation, but nothing else.
And you say recording of the minutes, is that because Belinda Crowe took the minutes?
Belinda Crowe was responsible for the minutes, the case administration, and producing bundles of documents for the cases we looked at an early stage to make sure the system was working properly.
I'm going to come back to the minutes later, so I won't deal with it now. Could we look, please, at page 15 of your statement? At paragraph 55, you refer to minutes for the 30th of January 2014 working group. And you say Post Office sought to narrow the terms of reference and JFSA objected. Chris Ojar went away to review the terms of Post Office and report back. He did not report to any other working group meeting and, to my recollection, simply imposed the Post Office new terms unilaterally to restrict the authority of the working group that effectively further slowed up the completion of cases, passing cases to mediation. Could we bring up those minutes, please? That's Poll 30026641. And if we we see it's the 30th of January 2014.
Yes.
If we can just scroll down slightly, please. Thank you. So we see there's a discussion about the terms of reference. And under action, it says Alan Bates raised the issue of scope of the working group and whether the intention was that the terms of reference would replace existing documentation, particularly, but not limited to, the raising concerns about Horizon documentation. And secondly, discussion then turned to the purpose set out for the working group, with the point being made that if the terms of reference superseded previous documentation, then JFSA felt the terms of reference as drafted were insufficiently broad. Is that what you were referring to in your statement as the challenge?
Yes. It was an attempt to narrow the terms of reference that the working group could look at.
And in what way was the attempt to narrow the terms of reference?
Comparing the two sets of documentation, the first set, prepared under Susan Crichton, was to embrace the reasons for the differences. The set of documentations, as I recall, the new terms of reference prepared by Chris Ojard, or someone under his direction, sought to limit anything the working group looked at solely to the Horizon computer system.
And we see there, it says, Post Office, responding for Post Office, Chris Ojard explained the terms of reference accurately reflected the purpose of the working group as explained to him when he had taken over as General Counsel, and that his understanding was that the working group's purpose was narrower than Alan Bates had set out. Pausing there, just as a slight detour, in your statement you refer to a change of tone and approach for the mediation when Chris Ojard replaced Suzanne Crichton. Can you explain what you mean by the change of tone?
Yes, Susan Crichton was a lawyer counsel for the Post Office who was trying to find out why differences had occurred, and it was under her instigation. We got two excellent investigators, Ron Warmington and Ian Henderson. It was under her instigation we had a training day for people sitting on the working group to understand the system. So it was a kind of open environment where access was given to documents to try and find the true reason for things. The second she disappeared without explanation and Chris Ojard replaced her, we had someone who appeared to be a litigation lawyer attempting to obstruct any access to documentation, slow things down, narrow the focus onto the narrowest of margins to limit damages for the Post Office. That's how it appeared to me. And
you appear to be suggesting that direction came from Chris Ojard. Was that anything he said or did that made you think that, or was it just a timing matter that once Susan Crichton left and Chris Ojard came, there was this change of tone?
The change of tone was obvious. It's not always reflected in the minutes by Belinda Crowe. But, for example, at the beginning of every meeting, Sir Anthony Hooper would ask, could the Post Office please explain what has happened to this money? Where are the suspense account items? Where has the money from sub-postmasters gone? And this is only referred to in two sets of minutes. One in November 2014. And Chris Ojard says he'll ask his accounts team to answer what is a really simple question, and it simply doesn't recur again. But at the start of every working group meeting, Sir Anthony Hooper asked that question. And Chris Ojard has simply blocked it and stopped anything happening with regard to revealing it. It is clear to me that he's there to close the scheme and close them down and make sure that we don't see anything that damages the Post Office brand. So yes, it was a change of tone and it came from Chris Ojard.
I'm going to look at suspense accounts later. Sticking with the terms of reference, could we bring up, please, Poll 30-26656? So this is the notes of the meeting on the 7th of March 2014. So we previously were at the January 2014. We're now 7th of March 2014. If we look down, please, to terms of reference, It says the working group discussed the revised terms of reference. The reworked clause 4.9 was agreed. Clause 4.10.1 was agreed, subject to the addition of the phrase "and any associated issues" after Horizon. It was confirmed that the terms of reference allowed for different lengths of mediation. It was agreed that the working group should not have its own budget, but use the process set out in Section 8 where funding was required. The terms of reference were agreed. Now, the inclusion there of the "and any associated issues" in Horizon, was that addressing the concern you had about the narrowing of the terms of reference?
It was supposed to make sure the previous issues were still included in the working group remit.
Why did you say supposed to?
Well, I don't believe it did. I mean, for example, one of the other things we discussed extensively was the retention of documents required for the cases. And bear in mind, we've got a lot more cases. We've got the 136 now, which is the 150 minus the ones the post office objected to. And every time, again, we'd say, please don't destroy any documents. And Chris Ojard would say, well, if there are issues in those documents and they're more than 6 years old, we'll probably have destroyed the documents. He made no effort to retain documents.
Well, let's look what you say on that in your witness statement, please. It's page 16 of your witness statement. Sorry, no, it's not. It's page 28. Thank you. So this is a section on concerns raised at the working group meetings. We'll be coming back here. I'm just going to deal with the paragraph 108 first. And you say that Sir Anthony Hooper asked how the documents for sub-postmasters and others affected cases were, other affected cases were being preserved. He warned Chris Ojard not to destroy any documents at all. Chris Ojard replied to Sir Anthony Hooper that Post Office Limited would continue to destroy documents following its usual 6-year statute of limitations document destruction policy. Can we just look at some minutes on that, please, starting with Poll 3026640. Now, as happens with some of these meetings, we have the standing agenda and attendees there. The date of the document is on the second page. It's the 23rd of January. Would that be 23rd of January 2014?
Yes, it would. These were telephone calls. We only met in person, I think, once a month.
Could we look at page 8, please, under AOB? So action, Post Office to reinforce the point that files not be destroyed, note to issue in Chris Ojard's name, including letter to Royal Mail and other relevant bodies. Do you recall that being discussed?
Yes, it was discussed at every meeting.
And if we can go, please, to Poll 3026635. And if we could just start at page 2 to date the document, Thursday, 6th of February. If we go back to the front page, please. We see that you're not in attendance at this meeting.
No.
Would you have reviewed the minutes?
Yes, I always reviewed the minutes when they came out.
Could we turn to page 5, please? And if we can go to the bottom of the page under 7. we have review of outstanding actions and reference number 28. It's the point we went to earlier at AOB. Post Office to reinforce the point that files are not be destroyed. And it says update correspondence issued to Royal Mail and from Royal Mail to Iron Mountain. Was it not the case that Post Office were taking steps or saying they were taking steps to not to destroy documentation?
Well, they said they'd corresponded with their previous head covering Royal Mail, which separated in 2012, and Royal Mail had stored some documents at Iron Mountain, so presumably they told Royal Mail since 2012 and earlier not to destroy documents. Didn't affect really what the Post Office was doing with their own documents. A lot of the cases being reviewed were pre-2012, so that was relevant. But whether it was complete, I can't say.
I want to, can we bring up your witness statement, please? Page 27, paragraph 101. You discuss here a practice by JFSA of retiring during discussion of individual cases. And by retiring, do you mean not participating in the discussion?
We left the room.
Left the room. So there was a development in the working group meetings where the originally agreed terms for the working group were unilaterally varied by Post Office when the working group attempted to discuss cases where Second Sight had recommended mediation. So this is Second Sight do the report. The Second Sight say we recommend mediation, and there were situations where Post Office wanted to have a discussion as to whether or not the working group actually recommended mediation. Is that a fair summary?
Yes, except Post Office had no authority to do that.
No authority to do what, sorry?
Well, at the point that the original terms of reference before Chris Ojard's version was that if Second Sight, having reviewed the claim, the Post Office inquiry report and the CIR by Second Sight, if Second Sight it said it's a case fit to mediate, it should go straight to mediation. Post Office had no right or authority to interrupt the flow to mediation and have a discussion at this point.
Can we look, please, at POL 3022120? It's the same document we went to earlier about criminal, just before the break, about criminal convictions. Could we turn, please, to page 2? If we go down there, perfect, thank you. This is describing the scheme, and the fourth paragraph down says, as a result of this investigation, Second Sight will produce a case review summarising its findings and a recommendation on whether the case is suitable for mediation. A copy of this case review will be provided to you. Pausing there, that this is aimed at an applicant, so postmaster, is it? So that you is the applicant.
Yes, this briefing document is for the claimants to make a claim, so it's to encourage them and explain how it will work.
Then says the working group will, however, take the final decision on any cases that may not be suitable for mediation.
That's correct. So any case that Second Sight have rejected or can't make a decision about, the working group should review. Ergo, it means that any case where Second Sight say it's suitable for mediation should go straight through.
Is it not the case that Second Sight would produce a recommendation which it was intended that the working group would then consider and arrive at a final decision?
No, it wasn't. The CIR, if it recommended mediation, should go straight to mediation. It's only cases where they didn't take a final decision.
What was the base? Where did you get that understanding from? That was the proper interpretation of what the working group's role was.
The working group will take a decision, final decision, on any cases that may not be suitable for mediation, not on cases that are suitable for mediation. That's what it says.
If we turn to page 8 as well, please. And will my case definitely be referred to mediation? I think this is a paragraph to which Sir Alan referred in his evidence to the inquiry. That if your case is suitable and you provide accurate, detailed information to Second Sight, then this is likely in most circumstances. However, the working group may consider that some cases are not suitable for mediation. For example, if there is insufficient information about a case or the case is not one for requiring resolution. How does that work with your interpretation of the role of the working group if it's only going to decide cases for mediation where Second Sight haven't made a recommendation?
The working group was intended to process cases and make sure they had the relevant information and inquiries made before going to mediation. My understanding, when this document was issued, is only in exceptional or strange circumstances when Second Sight, as competent investigators, couldn't make a decision or there was insufficient evidence, would the working group consider the case. So it meant that the majority of cases should have rolled through to mediation, and Post Office nor any other party around that table had the power to stop them.
The working group was chaired by Sir Anthony Hooper, a previous Court of Appeal judge, yes?
Yes.
I think Sir Anthony Hooper was your recommendation.
Sir Anthony Hooper was chairman of the Expert Witness Institute and I was its vice chairman. I knew him quite well.
Was the purpose of appointing someone like Sir Anthony Hooper with a legal background to assist with resolving issues such as whether a case can go for should go for mediation or not?
No, that wasn't the main purpose. The main purpose was to find someone of great integrity and knowledge of the resolution of disputes to make sure that the process produced by this mediation processing scheme was run fairly. I mean, it was an absolute bonus. He had substantial knowledge of criminal cases because he was able to review files where Post Office said this wasn't fit to mediate because this person was going to be prosecuted or had a criminal conviction. Sir Anthony went and reviewed the files, and in every case he said, that's not true, they can go through.
I want to look at a few of the meetings where the issue of whether or not to mediate came up. Could we start, please, with poll 26673? So this is, hopefully the date is on the first page. It's the 16th of June 2014. Could we go to page 3, please? Sorry, page 2. And if we can go down to have point 3 at the top of the document. This case MO5, well, I'll say M54, was discussed to inform a decision as to whether the working group should recommend the case for mediation. Second Sight had, in their final report, recommended mediation. It says the following points were considered during the course of the discussion. Regardless of a decision to recommend mediation by the working group, either party had the right to decline to mediate. Now, did you disagree with that?
No, I think mediation has to be a consensual process.
So, the extent to which cases raise issues that had not been previously explained to the satisfaction of the applicant in the context of the benefit of mediation for the applicant in terms of being able to move on after mediation from the events being mediated. What does that mean?
This is a particularly difficult case because it involves someone who'd suffered, I believe, criminal conviction. I may be misremembering the number, but I think this is one where there was a criminal conviction and there was strong opposition from Chris Ojard in particular that you could mediate anything post a criminal conviction. But the financial loss was still there, whether they were convicted of something criminal or not. And if their conviction was based on some misinterpretation or some plea bargain under false circumstances with limited disclosure, we all felt that they should still have the opportunity to go face to face and discuss the financial issues.
So was this a case where Second Sight had recommended mediation, the JFSA were in favour of mediation, but Post Office were against mediation?
Yes, because there'd been a plea bargain in this case, if I'm, again, interpreting the number correctly. And this individual had plea bargained to false accounting to avoid a theft charge and going to prison. But whether they'd actually done false accounting or not was pretty dubious.
If we go to the bottom of the page, it says, it being apparent that the matter of whether the working group should recommend M54 for mediation might proceed to a vote, the working group agreed the test the chair should consider, if called upon to use his casting vote as, on the assumption that both parties approach mediation in a genuine attempt to reconcile their differences, is it reasonably likely that the parties will reach an agreed resolution of their issues? And then over the page, it says the working group moved on to a vote, Post Office voted against, JFSA voted for, and the chair undertook to decide the matter and provide the working group with his reasoned written decision. So at this point, were the JFSA engaging in a position where the working group were going to determine whether or not to recommend a mediation in circumstances where Second Sight has recommended mediation?
Yes.
Why was that?
Because this is, I think, one of the first times this occurs, and it was somewhat of a curveball, because we'd previously understood the scheme. If mediation was recommended, it would go through. Post Office strongly objected and indicated they wouldn't take part in the mediation.
So is your evidence that this was being caught off guard, but you're engaging in the debate and the vote at the time?
Yes.
Can we look, please, to... Poll 30026665. So we've got a minute of the call on the 26th of June, which you see you're in attendance at. Please, can we go to page 12? Sorry, page 8. So we have M54, that's the case we were just discussing. And it said the chair asked all parties to consider the steps to be taken to inform, it should be their applicant, of the decision not to mediate the case. So it appears that Sir Anthony Hooper had decided against mediation or recommending mediation in this case. Is that correct?
That's correct.
And because KL, I assume that's you,
Yeah.
Raised a concern about sharing the chair's decision. The chair noted the concern, and then it says AB, presumably that's Sir Alan,
It is.
voiced concern about the additional time delay this would cause the applicant, but agreed the working group should take time to consider how to proceed in this case. And then if we can scroll down, please. We see at the bottom AB again. AB queried the role of the working group in the recommendation to mediate when Second Sight had recommended mediation. It was noted that this was the previously agreed process and the one followed in M54. Do you recall the discussion that led to this minute?
Yes, this is the point at which we objected, really, to the intrusion of the working group committee into the recommendations by Second Sight. It was clearly going to cause delay and distress for the applicants when they had cleared the hurdle of proving there was a dispute that could be mediated.
when it was said, it was noted that this was the previously agreed process and the one followed for M54. At that stage, were you in agreement that M54 had followed a previously agreed process?
No, that's the point. Belinda Crowe has written this minute. The first half of the second sentence belongs with the first. AB queried the role of the working group in recommendation to mediate when Second Sight had recommended mediation, which was noted this was the previous agreed process. Stop. This was different from the one followed for MO54.
I can come down, thank you. I don't propose to take you to minutes of other working group meetings, but I can if you like. They show, as you said earlier, that JFSA from then on would leave the room or not participate in discussions when the working group were deciding whether or not to recommend a case for mediation.
That's correct. I mean, the latter meetings were held at Matrix Chambers rather than Bond Dickinson Womble's offices. But we left the room and sometimes the building until they'd finished dealing with their interference in the scheme, because frankly it was a power the working group did not have, whatever Chris Ojard's explanation was when he joined Post Office.
And was it the case that Sir Anthony tried to encourage the JFSA to stay for that discussion?
He did, but I don't criticise him for that. He simply wanted a straightforward way forward for the claimants who were being caught up in this battle.
And could you explain the basis on which, or the reasons for, not participating in those discussions, other than you've given evidence that it wasn't the agreed process? Were there any further reasons for not participating in the discussion?
Not only was it not the agreed process, it was not what had been advertised to the claimants when they made an application to join the scheme. Once you've joined a scheme and the rules are set, you can't then do what Post Office often did, which is slip change into some other shape. So you do something different. You've got the people on board, so then suddenly they're not going to Clacton-on-Sea, they're off to Scarborough.
I want to move on, still in the time of the working group, but could we bring up your statement, please, at paragraph 91, which is page 24.
Is this the second 91?
You're quite right, yes, it's the second 91.
Apologies for that.
No, none needed. So it's the one, when it arrives on screen, it is meeting with Paula Venables. So if we could go to the yes, if we could go to the bottom of the page, please. So this refers to a meeting you had, I think it's a coincidental meeting where you bumped into Paula Venables at Bonn Airport in Germany on the 17th of September 2014.
I was waiting for my flight by the gate and she hove into view with two other people from the Post Office.
You say in your statement, I will come to the email shortly, that you've now seen an extremely inaccurate file note of that conversation. When did you first see what you describe as the inaccurate file note?
In the papers for this inquiry.
Before seeing that file, or what you describe as the file note, would you have recollected this conversation with Paula Venables?
Yes, I remember meeting her at the airport and bearding her, if that's the correct phrase, with some sort of encouragement for her to settle and at least face up to the claimants and explain to them what had happened and pay them back their money.
Let's look at the note, actually. We'll go straight there. It's Paul, 2 zeros, 101367. So it's an email from Paula Venables to Chris Ojar. It's on the 17th of September. So this is made on the day of the meeting. Is that right?
It's the 17th of September is when I saw her at Bonn Airport.
Do you remember roughly what time the meeting was?
No, I can't. It was in the morning or around lunchtime, at a guess.
But you would accept that this is a contemporaneous account. I appreciate you dispute the accuracy of it, but it was made on the day of the meeting.
Well, it appears Miss Venables has sent an email on the same day, yes.
It says that it refers to just bumping into you at Bonn Airport, had a chat together off the record, but of course not really. Do you know what that it means or what would lead to that impression?
Well, I did say that. I said, you know, Paula, can I have a word off the record? Because I do think you need to settle this, because the sub-postmasters need their money back and they ought to have some sort of face-to-face explanation to explain why they've been treated so badly for so long. And if you don't settle this, you'll regret it.
It says, I'm not going to go through all of the document. I think it's the fourth bullet point down. Can we get Angela to lead on mediations? Particularly if we think we are unlikely to move our position. Kay's view is she is credible, understandable, brackets, v important, close brackets, and stands the best chance of getting people on side, or at least to feel they have been listened to, even if they still disagree. Now, take it in stages. Is Angela in that bullet point referring to Angela van den Bogart?
Definitely Angela van den Bogart.
Did you discuss Angela van den Bogart in your meeting with Paula Venables?
Yes, we did, because she was getting to the bottom of an investigation which seemed to have been carried out for the first time on any of the applicants' cases, and we're actually finding out why the differences had occurred. So she was very thorough, easy to understand in her explanations of how differences arose, and if you cut her in half, she'd be post office through and through.
Did you say that if she about being post office through and through?
No, I did not say that to Paula Venables.
So the point that Kay's view is she is credible, understandable, is that a fair comment for Paula Venables to have made?
Concerning the investigation of differences in the network, yes, but not generally.
So we should consider being more open to mediation on the cases where more money was at stake, not less, because this had a greater emotional impact on those affected, brackets, lost jobs, homes, etc., close brackets, and therefore they are the ones who need to vent more and who would benefit from us allowing them to yell at us. She thinks we're big enough to take that.
Where on earth has that come from?
So, what is, do you? That was about to be my question. From what was said at the meet, or do you recall anything being said at the meeting that would lead to this note being made?
No.
We then have. It says Joe Harrison brackets JA-SPMR. Now that's presumably means Joe Hamilton, James Arbuthnot, sub-postmaster.
Yes, I'm pretty certain it's Hamilton, not Harrison.
Kay intends to go into mediation with her. She thinks she needs looking after. Kay indicated that Joe had done something wrong but feels sorry for her. Now I'm going to pause there because I know you dispute that. What is your recollection of what was said about Joe Hamilton at this meeting?
My recollection is I said the system was such that Joe had been muddled and concerned, very upset, and had had to roll over a difference, which Angela had said when we discussed MO35, that was a reason she couldn't get to the bottom of the reasons for the difference because it had been rolled forward over so many periods. I didn't feel sorry for Joe. I did say she might have got out of her depth with the system, but she didn't have any documentation to check, which isn't in the note. And I thought they could have been more sympathetic than taking someone into her home and interviewing her without anyone else present and attempting to take her goods, which was prevented by her mother. I don't remember saying Joe had evidence that they hadn't got at the time of prosecution. I probably did say Joe should have had information disclosed by post office that wasn't available at the time of prosecution. This is a complete misrepresentation of what I said.
Would you have said, as part of the discussion generally about the fact of a guilty plea, whether or not you agreed with that guilty plea, would you have mentioned that?
No, I don't believe we discussed prosecutions or guilty pleas as far as I recall. My notes of this conversation have not been reduced to a file note at the time. They were in passing at an airport.
Thank you. That document can come down. I want to go back to one of the 2 points you raised, one of them I said I'd come back to. It's page 28 of your statement, please, paragraph 107. And if you could go to the bottom, please. Thank you. So these are the two of the concerns that you raised here. We looked at 108 earlier. 107 is the question, where has the sub-postmaster's money gone? And you say that Sir Anthony Hooper asked that question regularly.
Yes, he did.
Now, you say that Post Office, at the end of that paragraph, Post Office failed to provide any explanation or figures at all. That's in relation to where's the money gone. Chris Ojar said he would get this information on several occasions, but he never did. I just want to look at a few of the meetings on this issue, and could we start, please, with Poll 30-26685. So this is a meeting on the 16th of September 2014. We see you're in attendance. Could we look at page 6, please? And if we go down to have suspense account paper, sure, thank you. So suspense account paper. Now, you do say in your witness statement that there were at least two types of suspense account potentially relevant. What type of suspense account was being discussed here?
We should be discussing what I would call the head office suspense account, where differences were posted in the main Post Office Limited accounting system. And I would expect it to include things like the differences on reconciling Camelot or Bank of Ireland controls accounts. But it must be that place where the sub-postmaster's money had gone. And I know, talking to Ron and Ian at the working group, they definitely volunteered many times to go to Chesterfield or wherever the accounts were held and have a look for themselves to actually ascertain what had happened to the money. Chris Ojard, on many occasions, confirmed that wasn't necessary, it was too complicated, they weren't going to be paid for it, and he would produce a paper from his accounts team asking the CFA. I've no idea what this paper was, but I don't believe it was a substantial explanation.
So, but this part here where the Post Office explained they provided with a paper, you say you don't know what that was?
No, I've never seen it.
Post Office explained that the request was too broad and they could not see how it linked to any case at Second Sight, which we were investigating. Second Sight undertook to provide their further specific questions in writing to Post Office. Could we look at the meeting on the 17th of October, which is Poll 3040475? So the 18th of October, as I say, could we go to page 2, please? And this is referring back to the minutes of the 16th of September meeting. So referring to page 6, item 5, Second Sight had written to Post Office with questions on the suspense account, but had yet to receive a response. The Chair noted the complexity of the questions. He asked if there was a surplus in the account, would it be taken into Post Office income? Post Office confirmed that it would after 3 years. Post Office and Second Sight agreed to clarify Second Sight's precise needs for information. So the Chair asked Post Office for figures taken into income from the suspense account to be broken down year by year. Now, firstly, do you recall this conversation beyond what's recorded in the minutes?
I remember a November 2014 minute where Chris Ojard gave a specific undertaking. I can't remember the wording, and that information was never followed up. But I know from my own investigations that there were amounts of over £1 million taken to the Post Office profit and loss account over a 5-year period.
I think you've answered the question I was about to ask on what came next. I'm going to jump forward to the 14th of January, please. Poll 3043633. And we see 14th of January 2015. Could we go, please, to page 3? And to the bottom of the page. Thank you. So it's additional agenda item, update on Part 2 report. So that's the Second Sight Part 2 report.
Yes.
And the Chair asked for an update on progress of various matters. And at the bottom we see the Chair asked if Post Office was able to answer the question on suspense accounts that had been posed for several months. Ian reported that the information had not yet been provided. The Chair asked that this be addressed as a matter of urgency and suggested that Post Office arrange a meeting between Second Sight and Post Office finance staff to do so. Now, the inquiry has heard evidence and there's documentary evidence on matters that happened thereafter. My question to you on this is, were you involved at all in this investigation into suspense accounts?
No, I was not.
Did Ron Warmington or Ian Henderson tell you anything following this meeting about that investigation?
In about 2015, I brought the paper to remind me, I was told by Ian Henderson the amounts credited to the profit and loss account of Post Office in 2010-11 was £612,000. In 2011-12 was £207,000. In 2012-13 was £234,000. And in 2013-14 was £104,000.
Okay, as you're reading from a document, is that a note of a conversation?
It's a note of a conversation I had with him. I've highlighted it in yellow so I could find it.
But it's gone off my. That was Ian Henderson who told you that.
That's correct.
Did you have any further involvement in investigating suspense accounts?
There was no opportunity because the mediation working scheme was cancelled unilaterally by Post Office without that question ever being answered.
I want to now turn, that document can come down, thank you, to my final topic, and it's what happened thereafter, and the group litigation. Oh, sorry, sir.
No, before you do, am I right in thinking that either Mr. Henderson or Mr. Warmington had, in their witness statement, when they gave evidence, figures either identical to or very similar to the ones which Ms. Linnell has just referred to?
So off the top of my head, I couldn't say with confidence, but I at the break we'll double check that point.
Okay, I don't think I'm imagining that. That's all.
If it assists, they're in the published accounts.
Right. So there's a public record of them somewhere. Anyway, yeah, fine. Well, you needn't go researching then, Mr. Stephen.
It shows the confidence in my memory. Turning then to the litigation, please. I asked earlier about the prospect of litigation in 2012, and my understanding of your answer was that you need funding for litigation.
Yes.
And in order to get funding, you needed to have sufficient information to show a basis to put forward your claim.
Yeah, and a reasonable chance of success, or no sensible lawyer would take it on.
I know I'm going to ask you some questions about the process of litigation, but remember, I'm not asking you anything which would require you to provide privileged information unless you were in a position to waive it and you wanted to waive it.
Thank you.
Once the mediation scheme had finished, so in 2015...
It was abruptly ended by Post Office in 2015, and I had a letter from Jane McLeod out of the blue.
How easy or difficult was it for you to find legal representation for the group litigation?
Sir Alan and I did several things at the end of the mediation scheme. First of all, we had a look at the evidence that had been produced by the Post Office and Angela van den Bogart. We also, without wishing to pierce privilege of mediation discussions, had some general feedback from those people who had been fortunate enough to reach the mediation panel. And thirdly, we started putting together a panel of potential lawyers who had experience in group litigation. We then went to several firms of lawyers, and as happenstance would have it, we ended up with Freeth, who also introduced us to litigation funders, after the event insurers, and counsel, Henderson Chambers.
And it's well known that the litigation was funded by a litigation-funded Therium.
Therium were the funders, yes.
If you hadn't had a funding by way of a funder such as Therium, would the GLO claimants have been able to pursue the litigation?
No, they wouldn't. And if they hadn't had generous solicitors and counsel prepared to take a proportion on a conditional fee success arrangement, we wouldn't have been able to process either. And the funders recognised the importance of having after the event insurers for people in our claimant's position. So we had to put all those four pieces in place before proceeding to litigation.
Just for the benefit of the public, when you say after the event insurer, do you mean an insurer who would indemnify the claimants if the litigation was unsuccessful and a cost order was made against them?
If you look at the case of Lee Castleton, it's very clear. If you lose in a court and the court has the power to award costs against you, it can have severe financial implications. The purpose of after the event insurance is to put an insurance policy in place, so if you lose, the insurance policy coughs up and pays the costs.
So, as I understand it, you say these sort of essential ingredients were A, Therium or a litigation funder, B, the after the event insurer, and C, solicitors and barristers who were prepared to take a portion of their fees on a conditional fee basis or a no-window fee basis?
Yes, bearing in mind all are essential, so you could take them all as one. There's no priority in that listing. And to get the solicitors and barristers interested, you have to have sufficient evidence to prove that something's been done wrong, and there is similarity across a group of claimants so that there are sufficient to actually put a force together to form a group litigation group. Quite high hurdles to overcome.
And the just rounding this off, the information that you were able to obtain and put forward to the solicitors and barristers to get them interested, did that come from the mediation scheme?
Yes, one of the things about going into the mediation scheme, because normally anything discovered in mediation is privileged and within the bubble of mediation. But one of the things JFSA managed to negotiate is any document disclosed in the mediation would be usable by the claimant person. So yes, that's where the data came from to enable litigation to take place.
Before I ask another question about the GLO then, to what extent, if at all, do you think the mediation scheme fulfilled its purpose?
At least 85 or 90%. Without the mediation scheme, there wouldn't have been the volume and capacity of claimants to go forward, because Post Office has, throughout my involvement with them, deliberately or otherwise withheld documents that are essential for the defence of individuals or the prosecution of a claim.
Can we look at page 31 of your statement?
So again, Mr. Stevens, sorry, but if it be the case that the Post Office was seeking to use the mediation scheme as a sham, to use that word, in fact, on your view of it, it had the opposite effect because it provided you with the ammunition for the litigation that followed.
Yes, that's exactly right.
Fine, okay.
Paragraph 119 and 120, you say that the Freeth legal team put in place all the necessary mechanisms and steps to cope with and respond to the aggressive Post Office litigation strategy, which in my view and the view of others was primarily designed to run the group litigation claimants out of funding. Mr. Justice Fraser refers to this in his judgment by implication. And you go on to specify what you saw as the aggressive litigation tactics by saying they included limited and sporadic late disclosure, contested cost applications and other litigation tricks such as Post Office's recusal application to derail the planned 5-trial litigation. I want to just focus on one aspect of that, and that's the recusal application. Can you were you in court when the recusal application was announced?
Yes, I was.
And what was your reaction to that?
It happened after lunch in the middle of someone's testimony. And I think Mr. Degar Robinson stood up and made the application. Fraser J insisted the witness was completed before he dealt with it, which was kind, because otherwise the witness would have been held over indefinitely. And I think it was an absolutely shocking result, because it was the tactics of a desperate drowning man, as far as I could see. To recuse a judge who had been no more than colourful in his language and comparatives. It was the handing down of the first judgment that same morning. And there were phrases in it which clearly the Post Office and their legal team objected to, such as the Flat Earth Society and things like that. And I think it was absolutely disgraceful because there was no bias that I could see in that judgment. However, I'm not a lawyer, I'm a mere accountant. But I thought it was a disgraceful tactic and designed to stop the trial on the Horizon system, add huge legal costs to our side, and to try and derail the whole process.
Did you speak to other people in the claimant group about the fact of the recusal application being made?
I certainly did, because people wanted to understand what it was.
And can you summarise what the general feeling was within the claimant group about the application having been made?
I can only say this from my personal point of view. I think there was some anger and frustration as yet another tactic by Post Office stopped the move slowly towards redress, justice, and some sort of conclusion as to what had happened to them.
The final question, or possibly questions I ask, is about interaction with government. Now, when Sir Alan gave evidence, Mr Beer presented a series of letters that he had sent to ministers and went through various meetings. Did you have any interactions with government or government ministers in respect of the Horizon IT system?
Sir Alan and I decided that he should write the letters. We discussed the contents before they were sent. In particular, I was a part of his issuing of a bill to, I think, the Prime Minister at the time, Boris Johnson, concerning the litigation costs of 46 million plus interest.
Thank you. So before I say, I shouldn't, famous last words saying this is my last question. If I may just have a moment to check a note. Thank you. So I do actually have one further question, and it's going right back to the start of your evidence when you referred to working for a firm called BDO.
Yes.
We've heard evidence about Lee Castleton's civil case and an expert report being produced to Womblebon Dickinson, not disclosed in the hearing, by BDO, or sorry, BVO Stoy-Haywen. Did you have any involvement in the Lee Castleton case at all?
No, I really wasn't aware of Lee Castleton's case till I met Alan Bates and we went into this process.
I'm not suggesting it's necessarily the same firm.
It will be the same firm.
Will be the same.
Because Stoy-Haywood and BDO, which was formerly BDO Binder Hamlin, amalgamated at some point, but I wasn't involved in such high echelons of the firm to know anything about that.
Thank you, sir. Those are the questions I have. Now, Ms Linnell is represented by Mr Steen, and would like to ask questions in re-examination under Rule 10.2, which, subject to your approval, I think is open to them. I think if we are doing that, though, first, I will check if there are other co-participants who wish to ask questions. No, sir. So I think Mr Steen has 2 questions.
Literally 2, Mr. Steen.
2 topics, sir.
Sorry.
Well, no, I'm just concerned about the shorthand writer, that's all. If you're going to be literally a few minutes, I'm sure she'd prefer to finish. But if it's more than that, we'll ask her which she'd prefer.
Our shorthand writer is confirming that if it's a few minutes, then to go ahead, and it will be, sir.
Thanks.
So the reference in Mr Warmington's statement to the suspense account monies is his statement, WITN 01050-200, page 7, paragraph 12, and the figure of £612,000 is given. And you'll recall I asked him questions about that matter, and he referred to other sums.
Yeah.
Ms Linnell, just 2 topics, as I mentioned to Sir Wynne. You were asked a question by Mr Stevens about your first joining meetings of the JFSA. And we all know from the ITV drama that the meetings were sometimes at village halls, Benny Compton famously, otherwise at Finton on occasions. Now, regarding funding, which was what you were asked by Mr Stevens, how broke were the sub-postmasters that you met at these meetings?
Very broken in minus red land, as my friend used to call it, with lots of credit card and other debts hanging around them.
Sometimes in relation to your support of sub-postmaster mistresses, working with Mrs Jeremiah, you were helping them try and make their way through the mess that had been made of their finances. That needed on occasions to get things like bank statements, which aren't necessarily free. How did you manage to do that?
Barbara and I paid for them.
Another question that was asked by Mr Stevens was regarding the JFSA and whether it engaged with the National Federation of Sub-Postmasters. Was there any desire amongst the people that you met at the JFSA to engage with the NFSP?
The feeling among people I spoke to who are SPMs is that the National Federation of Sub-Postmasters were no more than part of Post Office and not to be trusted.
So thank you.
Well, first of all, should I be calling you Dr. Linnell?
You could, sir.
Well, I just, hidden amongst your witness statement was a reference to you becoming a doctor in 2024. So, Dr. Linnell, thank you very much for your witness statement, and thank you very much for giving evidence before me this afternoon.
Thank you, sir.
Thank you, sir. And I'll apologise for repeatedly saying Ms Linnell all the way through.
No, I'm happy.
I just like everybody to know that I do read the lines of the witness statement, Mr. Stevens, that's all. Thank you very much, everyone. And 9:45 tomorrow, yeah?
Yes, sir. Thank you.